Start with the call of the docket. We have the jail, I think it's on Zoom as well.
No.
I'm admitting the jail so they can come in.
Should be lost.
See if we can get the jail to turn on their camera. Hi, good morning. We'll start with the call of the docket. You want to call the first case, please? I'll call it. Docket number 2024 CR 19604, State versus Ryan Scott Babcock. This is Mr. Lockert's case.
Yes, Your Honor. We just need a trial date, Your Honor.
Our November dates, are they all full so far? As far as we know, we had given out November the 17th, 18th, 19th, possibly the 20th. I don't have it. I don't show it. All right. What about the 17th of November?
My mistake. Is that what Baxter is?
All right. So Mr. Babcock understands this is his final day to settle his case, and when I set it for trial on the 17th of November, he'll either plead to the indictment, go to sentencing as to all charges, and or go to trial. So.
Your Honor, if we could still leave this open for settlement, the reason it's taken so long, the victim's in the military, and the district attorney's office is trying to get in touch with the victim and talk to him. So I don't want to foreclose settlement, but that trial date's fine.
We'll set it for trial. We'll see. I mean, if obviously if there's some extenuating circumstance between the state and the defense, you just need to let me know, and we'll see what we can do.
Thank you, Your Honor.
2020 November 14th. You want to put it? All right. So the docket that we have is the 10th of November. That's where I was confused. Mr. Locker, we'll just go ahead and set it on the 10th of November just to ensure that it's ready for trial. So.
Thank you, Your Honor.
All right. Someone would let the jail know we're ready for them whenever they want to come in. I'll skip over the jail cases until they're ready. 2024 CR 19623, State versus Alexander Beecham.
Your Honor, I think we had some communication with Ms. Turin, and the state's in agreement to dismiss it. He's, I think, paid all of his court costs. So.
All right. Case is dismissed by the state pursuant to their agreement. 2026 CR 19894, State versus J.D. Allen Binkley.
Your Honor, can we second call this one? The lawyer will be back in just a second.
I'm sorry.
Can we second call this one? We'll be back in just a second.
Put it on the second call. State versus Fletcher Dale Balling Jr.
Judge, I've represented Mr. Bolden for quite some time. I'm not sure that he knew about this court date. I just saw him a couple of weeks ago in sessions. If we can put this on the 28th, I can call him.
July 28th. 2026 CR 19853 State versus Charles Wandle Chambliss. That's also for the July 28th date. Is that correct?
That's correct, Judge.
We'll move that to July 28th for a possible plea. 2023 CR 19434 State versus Timothy Douglas Clark. And that is for status or competency review. How did we leave that?
Judge, I have a report from my forensic psychologist that differs from what Ms. Donna Moore found. We probably are just going to have a competence hearing some point in the future. I need to give that to General Willoughby.
Once you have received that, if you will reach out to me, we'll see if we can schedule it. Both sides agree, well, if necessary, to hear that out of county.
Yes, sir.
All right. Then we'll show that's to be set. So. All right. And he is in jail. We don't need him, I assume.
No,
correctly.
sir. We do not.
Let's put it on November 10th just to make sure it doesn't fall between the cracks. But thank you. 2024 CR 19647 State versus Patrick Coombs.
Good morning, Your Honor.
Good morning.
Mr. Combs is a capias has been issued on him. He is presently in Williamson County Jail. We found him in Georgia. Williamson County had a capias on him. Robertson County had a capias on him. So he's been brought back with everybody's assistance back, and he's now in Williamson County. He had a plea deal on the 13th in Williamson County. Cheatham has a hold on him, a detainer on him. I've got a copy of all the correspondence. If that could be put with the file.
And your motion is to be relieved from bond based on the fact that he's now been taken into custody.
That is correct. And that is the correspondence between Cheatham County and Williamson County.
Do you want me to put this in the court file, or do you want
Yes,
it back?
no, I can put it in the court file, please.
All right. You have proven good grounds, and that the court finds that you should be released.
Thank you very much, Your Honor.
Let's set Mr. Coombs. It's not a case that I have to hear, is it? Since we have a hold on him, let's just put him for next month on the criminal docket call to see if they've been able to get him over here. 2026 CR 19870 State versus John D. Cottrell. John D. Cottrell for arraignment.
Your Honor, he was bound over back in March. His case went to grand jury. He was indicted on counts 1 and 2. Count 3 came back as a no trivial, and he is on a $5,000 bond now.
Was he told to be here yesterday?
He was given a card back in sessions, but I don't know if it was back in March. I don't know if he would have known.
All right, but he has a bond on this.
He does.
Let's set it for the 28th, just out of an abundance. Since I had to move the docket from yesterday to today, in fairness to him, we'll move it to the 28th for arraignment. But if your office could notify his bonding company that he needs to be here on that day. Good morning at the jail.
Good morning, Your Honor.
You want to? Do you have someone ready for us to take up? We'll take them up whenever you're ready.
Yes, Your Honor. I think that you.
While we're waiting on the jail, let me go ahead and take up 2026 CR 19890 State versus Dallas Elkins. Dallas Elkins. All right, at the jail, who do we have? What's your name?
Give me a link. Zachary Mel.
Judge, my office represents
Mr. Mall, okay.
Mr. Mel.
Mr. Mall, I think the state and the defense have agreed that they should set a trial date for your case. And that we're looking at probably 2027.
Certainly.
So we'd be looking at March. And I can give you this. How long do we think it'll take?
That sounds like at least 4 days.
I would say so, Your Honor.
Probably a full week.
The 16th through the 19th. 16th through the 19th of March.
It's so far out that surely I will have to. Yeah.
All right, Mrs. Mal, we are setting your case for trial for 4 days on the 16th, beginning the 16th day of March, and continuing until the 19th. Your lawyer will be in touch with you and make sure you're ready. Thank you.
Yes, sir. No good. The judge is already on. Oh, yeah. This is Brandon Sanders on page 7, Your Honor.
All right. All right, Mr. Sanders, I'm shown here, it's a hearing on missing jail credits.
Yes, sir.
So, Judge, this was Mr. Richter's case. He looked at all the jail credits, gave him everything he was due. He's got everything that he should have. So I don't know anything about this. I would ask if he wants a hearing to set that on Judge Wallace's docket.
Mr. Sanders, we appointed the public defender's office to look into your case to make sure that you were getting all of your credits that you were entitled to. And they tell me that they've reviewed everything and that you are in fact getting all your credits. If you contest that, then I'm going to have to set you a hearing date in front of Judge Wallace.
Okay, yeah, I definitely contest it. I got put in jail March the 2nd. They got my time started in July the 29th. That's about 5 months I'm missing, you know what I mean? I was in jail the whole time.
All right. What is Judge Wallace's criminal docket?
I'd say put that on VOP day.
You want the VOP day? Be August 25th. We're going to set it for hearing August 5th in front of Judge Larry Wallace.
All right.
Thank you.
Yes, sir. Thank you.
Your Honor,
Yes, sir.
right up above that Dallas Elkins, I
Right.
just turned in a waiver of arraignment filed by Mr. Potter.
We have a waiver of arraignment in the court files, so Tim Potter will be shown as the attorney of record. We want to set a new status date.
I think that August 11th. Correct. That's my understanding. This will be on the even month rotation, so August 11th will be the status.
August 11th.
Yes.
All right, August the 11th for status.
Thank you, Your Honor. I'll let Mr. Potter know.
All right, thank you. At the jail, what is your name?
Your Honor, it's Kenneth Bearden on page 1.
Judge, Mr.
Kenneth Bearden.
That's Mr. Bearden is for plea today, Judge. I don't know if you want to do that here.
We
While I
probably, since we're close, we'll just bring him in. We need Mr. Bearden brought in so he can enter his plea.
I think somebody that was standing here.
All right, 2025 CR 19770 State versus Andrew Eugene Fox. My understanding that you have requested to set this for a final status day. Is that correct?
Yes, Judge. Mr. Fox has had some life events go on and just needs to have one more status day.
All right, I will set one final status day, and that means that, Mr. Fox, you need to understand that if you do not agree or do not work something out, we're going to assign you a trial date, and you'll either go to trial or plead to the indictment. You understand?
Yes, sir.
Status day will be November the 10th.
Thank you, Judge.
Thank you, Your Honor.
All right, at the jail, who are we got?
Your Honor, this is Roy Mayo on page 5.
Mr. Mayo, your lawyer, Mr. Fuson, was scheduled to be here yesterday, and when we had to move the court docket until today, he is unable to be here today. So he has asked that your case be moved to next week on the 28th. Maybe not next week, but on July 28th, we're going to have you here on July 28th for your lawyer. It'll be your final opportunity to settle your case.
Thank you.
Thank you. 2025 CR 19683 State versus Terralandis Fritz. Final plea day.
I've spoken to Mr. Waldman. We talked about getting a trial date. But I haven't heard from Mr. Waldman today.
So we're looking at setting him a trial date.
Yes, sir.
All right, that would be November the
Judge.
November the 18th. Wait a minute. Ryan Babcock got just set for trial on the 17th. Is that a one-day trial, we think?
Probably two.
All right, then let's set Mr. Fritz on the 19th. Okay, at the jail, what is your name?
This is James Doris, Your Honor, on page 3.
Judge, I represent Mr. Doris. I spoke to General Sylvie. He's got a VOP on an aggravated assault. It was 100%er, and he has served that. So at this point in time, we're going to dismiss the violation and terminate his probation. He's done his time, Judge.
All right, case is dismissed and his probation is terminated. Thank you, Mr. Doris.
Hey, Judge.
Ready? Good news today?
Where can I go?
Well, as soon as we get paperwork, we'll process you out.
Moving to page 4, 2026 CR 19843 State versus John Anthony Hodge.
Your Honor, I'm standing in for Mr. Greg King on this.
All right, Greg King is his attorney.
Yeah, it's supposed to.
And it was for status today. Are we ready to set it for trial?
I thought it was he just texted me about this yesterday, so I don't really know much about it.
Everything's, my lawyers told me that this was going to be put off to the 28th. I've got a violation of probation and I don't know, something's going on.
Hold on
But
one
I
second.
show them my license then and they're supposed to reinstate me.
Your Honor,
That's,
so my understanding is this is on for an arraignment today, and he is asking that it be set for the 28th to see if we can resolve it.
I don't think it's for arraignment. I think it's for status, but I'll move it to the 28th to let Mr. King be present. So
Perfect. Thank you, Your Honor.
thank you.
July 28th. All right, at the jail, what is your name?
Your Honor, this is Walter Nickens on page 5.
All right, thank you. Mr. Nickens, you are here to be arraigned on a charge of aggravated sexual battery. You have the right to an attorney to represent you. Do you wish to have a lawyer?
I don't know.
I'm going to appoint you a lawyer because I think you need one. So I'm appointing the public defender to represent you. And they're here in the courtroom. So I'm going to hand them a copy of your indictment. And Mr. Dickens, you are going to have a lawyer representing you, and Mr. Vaughn is here, and he's been handed a copy of that.
We'll waive formal reading, enter plea not guilty, Judge.
Plea of not guilty is entered. We'll set it for status on what day?
Whatever your next.
November the 10th.
This is ours.
Yes, that'll be mine.
All right, you've got a lawyer. He's going to come talk to you as soon as he can, and he'll get you ready for either a disposition or a trial. You understand that?
No, sir, I don't.
Okay. You understand what you're charged with. You're charged with aggravated sexual battery. It is a felony offense.
Okay.
And you now have a lawyer representing you, and that lawyer is going to come and talk to you, and Mr. Vaughn is going to explain to you what you're charged with and what their allegations are and what possible defenses you might have. Okay? He'll come talk to you.
Yes, sir.
All right. Thank you.
Ready, Mr. Nickens?
Uh,
You gonna go back to the cell?
All right. We'll move to all right. Who do we have? What's your name, please?
This is Trevor Gibbs, Your Honor.
Trevor Gibbs on page 3 and page 4. Mr. Gibbs, you are here charged with rape of a child, and you have the right to an attorney. Do you wish to have a lawyer represent you?
Yeah.
Public defender?
We'll waive formal reading, enter plea not guilty, Judge.
Plea of not guilty is entered. I've given a copy of your charges to the public defender, Mr. Vaughn, who is here in the courtroom, and he is going to come and speak with you, but I have entered a plea of not guilty on your behalf, and we will set it for November the 10th.
Yes, sir, that'll be fine.
November the 10th will be your next status day. That'll give your lawyer time to get you ready. All right, thank you.
You ready? We got the next one ready? Docket. Have a seat. Right here? Yep. Your Honor, this is Michael Turcott on page 9.
Morning, Your Honor.
All right, Mr. Turcott, you're here today to be arraigned on a charge of violation of your probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, Your Honor.
All right, I'll appoint the public defender to represent you.
Judge, we'll waive formal reading, enter plea not guilty.
Plea of not guilty is entered. You want to set this for this month on the 28th?
Is it based on new charges?
They've been taken care of in Dickson.
You're done in Dickson?
Yes, sir.
We can put it on the 28th, Judge.
All right, July 28th. Your lawyer will be up to talk with you, get you ready for a hearing.
Thank you, Your Honor.
Mr. Greenwood? Your Honor, this is Jeremy Greenwood on page 4.
Your Honor, if we could move this to the 28th, I think it's going to plea. He was set for a plea before and missed the court date. He's been in jail since.
Mr. Greenwood, your lawyer is asking to move your case to July 28th, and I will agree to that and move you to the 28th to let Mr. Lockhart continue to work on your case. So we'll see you July 28th.
Thank you, sir.
Thank you.
Palmer? Right here, have a seat. Your Honor, this is Antoine Palmer on page 6.
Mr. Palmer, you are here to be arraigned on a charge of probation violation. You have the right to an attorney.
We'll enter a plea of not guilty on that, Judge.
Plea of not guilty is entered. Set it for July 28th. We're going to see you in a couple of weeks for a hearing. Thank you.
All right.
Skipworth. Your Honor, this is Raymond Skipworth on page 8.
All right, Mr. Skipworth, you're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Appoint the public defender who's here in the courtroom to represent you.
We'll enter a plea of not guilty on that, Judge.
Plea of not guilty is entered. We'll set it for July 28th unless you tell me it needs to be further away.
We can handle this on the 28th, Judge.
All right, July 28th. We'll see you in a couple of weeks.
Thank you, Judge.
Thank you.
Pickney.
I've got it. Yes, I do.
Your Honor, Jackson Pickney on page 6.
All right, this is for arraignment on a charge of violation of community corrections, but also there's an arraignment, excuse me, on a new charge of aggravated assault by strangulation, domestic assault, possession of methamphetamine, possession of drug paraphernalia, and theft. You have the right to an attorney for all of these charges. Do you wish to have a lawyer?
Yes, sir.
Public defender will be appointed.
We'll waive the formal reading and enter a plea of not guilty, Judge.
Plea of not guilty is entered. General Sylvia, this is her case. There she is. Do you want to set this in November or some other day?
Your Honor, we can go ahead and set it in November if that's okay with you.
That's fine with me.
We'll set it for status on November the 10th. Your lawyer needs time to look into this matter and talk with you about it and try to prepare you for either a disposition or a trial. So we're going to reset this for November the 10th to give him an opportunity to try to do that. So he'll be up to talk with you as soon as he can.
Just for clarification, Judge, I have a violation of community corrections. I don't have the indictment.
All right, sorry. Here's the
We'll waive a formal reading of that. Enter a plea of not guilty.
formal reading of the indictment has been waived. The plea of not guilty is entered on docket number 2026 CR 19856, and we just set both of these for status on November 10th.
All right, thank you, Your Honor.
Thank you.
Your Honor, this is Benjamin Richardson on page 6 and 7.
Mr. Richardson, you're here today to, my understanding, you have Winston Bond as your attorney.
That's correct, Judge. I have an offer for Mr. Richardson. If we can put this on the 28th, I think that we can resolve this.
Your lawyer says he's working on your case. He needs a few more weeks to get it done, so we'll move you to the July 28th date.
Thank you, Your Honor.
All right, thank you. That'll be your final status day.
Very much, Richardson. Clark. Your Honor, this is Timothy Clark on page 2.
Judge, we discussed Mr. Clark. We have his mental evaluation back from my private forensic psychologist, and we're going to try to figure out a day for competency here.
All right, Mr. Clark, it was set for today for us to determine the competency review, and we have conflicting reports from psychiatrists. So we're going to have to continue your case to show that it is going to be set for a hearing on the issue of your competency to stand trial. And right now, we're just setting it for November the 10th as a fail-safe to make sure it doesn't fall into the cracks. Your lawyer is going to be in touch with you to talk with you about when we're going to have a hearing, okay?
Okay.
All right, thank you.
Your Honor, this is Tuesday Dotson on page 2.
It's actually page 3, I think. So, all right, Ms. Dotson, you're here to be arraigned on the charge of statutory rape. You have the right to an attorney. Do you wish to have a lawyer represent you?
I have one.
Who is it?
It was me, Judge.
That was Mr. Vaughn. All right. Mr. Vaughn, I'll show that you are the attorney appointed by the court. We'll give you a copy of the indictment. Do you wish a formal reading?
I do not. Will enter a plea of not guilty, Judge.
Plea of not guilty is entered, setting this for November the 10th for status. Your lawyer's been given a copy of the indictment against you. He will be up to talk with you and see if he can get you ready for either a disposition or a trial date on November the 10th. Thank you.
Your Honor, that was the last one on our list.
All right, thank you. I had a Tanya Wills, Willis, Mr. Lockhart.
Yes, Your Honor.
Is that someone that you have in jail?
No, Your Honor, it was set for trial today, I think.
That's true.
Technically.
He's here. Okay.
So we just need to get another date.
All right, that's fine.
He's-
Thank you at the jail. We'll let you out. So
He's been in jail for some time.
he's here today, I think.
Yes, Your Honor. But I haven't had a chance to go through all the discovery. So I'd ask for a new date, but I'd still ask for leave to settle. And I don't even know the state will settle, but I'd like that opportunity.
You know, we adopted this rule that if we set you a trial date, then go into trial or pleading to the indictment.
I've made several attempts to settle this with Mr. Willis. He does not like the consequences. So
All right.
we could just need a trial date.
How long do we think it'll take to try it?
2 days. 2 days.
2 days. We have State versus Timothy Baxter set for the 12th and 13th. Is that a 2-day trial, General Sylvie?
Your Honor, that is, in actuality with the court, if you want to go ahead and set something second, I would. We may have that settled by the end of the month.
All right, November the 12th and 13th then for Mr. Willis. All right.
Your Honor, I'm supposed to have a medical procedure on the 13th. I think it'll probably go 2 days on Willis. So.
Well, we've got the 26th and 27th of November. Is that okay with you? It's Thanksgiving Day is the 26th.
We're going to try it on Thanksgiving.
I was just seeing if you were paying attention. That's really all.
Well, we're used to, we used to have a judge that would do that.
Yes,
Judge
I know.
Birch. We tried a vehicle homicide on New Year's Eve and New Year's Day one time. So.
And I am sitting in his chair, so or in his spot anyway. And you think you're gonna, if it's gonna go 2 days, and you're gonna have to have it on the 20th, is that right?
I'll see the 26th. I thought was what we were talking about.
Oh, I'm sorry, that's true.
You said 13th.
Oh,
12th
yes,
and 13th of November.
Yes, Your Honor.
We could do it on the 18th, and it would carry over to possibly to the 19th when you have Tara Linda's Fritz.
That would be fine.
All right. So on Mr. Willis's case, we're going to start it on the 18th, correct?
Yes, Your Honor.
All right. Tanya E. Willis is set for trial on the 18th of November. All right, I'll go back through the docket, took up those matters that were not jail cases. Looks like on page 4 of the docket, 2026 CR 19860 State versus Michael Deshaun Holt. And Mr. Vaughn, I believe you asked for that to be set for the November status date,
Correct, Judge.
November 10th. Pardon me. 2026 CR 19895 State versus Jonathan Kane Krantz. Mr. Krantz, you're here to be arraigned on an indictment charging you with theft of property between the value of between $10,000 and $60,000. You have the right to an attorney. You wish to have a lawyer represent you?
Yes, sir.
Are you planning to hire a lawyer?
No, sir.
You're saying you can't hire your own lawyer?
Yes, sir. I was appointed Mr. Vaughn in General Sessions.
Raise your right hand. Let's place you under oath.
I do.
We're going to have you fill out an affidavit of your income and expenses for me to determine at this level whether you're entitled to have an attorney or not. It's not an automatic that you had one at the lower court that you're automatically entitled to one here. So when you fill that out, you're going to be signing it under oath to make sure it's accurate, okay? I'll come back to you. 2026 CR 19888 State versus Sapphire Linton. Ms. Linton, you're here to be arraigned on an indictment charging you with custodial interference and especially aggravated kidnapping. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Are you planning to hire your own lawyer?
I'm not able to.
All right, raise your right hand. Let's place you under oath.
Yes.
All right, Ms. Linton, if you will fill out this affidavit of your income and expenses, we'll determine whether or not you qualify to have a lawyer
Yes, sir.
appointed. (2025 CR 19750 State versus Jason Christopher Mangum).
Your Honor, I spoke to Ms. Riggs. I don't know if he's here. I think we had an agreed order to move it to the 10th. She filed a motion about a week ago that I hadn't had time to really digest.
So you
To move it to November 10th for hearing.
November 10th. 2023 CR 19424 State versus Roy D. Mayo. I think we moved that to July 28th.
Correct, Your Honor.
All right. Remove Mr. Mayo. 2025 CR 19808 State versus Aaron Patrick Northcutt. Mr. Lockhart.
Your Honor, if we could set that on the 28th, I'm going to talk to him about withdrawing his motion to set aside his plea.
All right, July 28th.
Thank you, Your Honor.
(2020 CR 18932 State versus Dustin Lee Parker).
Judge, that's Mr. Richter's case. It's kind of been kicked along. I've been told by Mr. Richter that there is a mental status upcoming. We were just kind of keeping this on the docket as a temperature check.
It needs to stay on Judge Turnbow's docket is what I've been told.
Yes, sir.
So when would Judge Turnbow have a date?
Would that be October?
October 1st.
I'll let Mr. Richter know, Judge.
Thank you. 2026 CR 19882 State versus Stephen Irving Rue. Mr. Rue, you're here to be arraigned on an indictment charging you with assault on a law enforcement officer, driving under the influence and resisting a stop, arrest, or search. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, I do.
Are you planning to hire your own lawyer?
Yes, I am.
All right. I can either read this indictment to you in open court or you can read it yourself. Do you want me to read this to you in open court or you plan to read it yourself?
Read it myself.
show he's waived the formal reading of the indictment. Mr. Vaughn, you have something?
I was just gonna do it for him.
He's planning on hiring his own attorney. How long do you think it will take you to hire a lawyer, sir?
I'm going to go right after I leave here.
All right. I'm going to put you for August the 11th, and that will be when you need to try to bring your lawyer in.
Okay.
I've written that at the top, and it will show that you've been arraigned. The plea of not guilty is entered, and we'll set you for August the 11th to see if you're able to hire a lawyer.
Okay.
Thank you. You're free to go until then.
Oh.
2025 CR 19773, State versus Jack Howard Sanders.
I represent Mr. Sanders, Judge.
I believe we said that was going to be reset for 1 year.
That'll be reset for 1 year and then retired, Judge.
Yes, Your Honor.
All right. Matter is reset for 1 year, which would be July. July the 13th. July the 13th of 2027.
Perfect. Thank you, Judge.
(2026) CR 19886, State versus Nathan Sandage for arraignment.
Your Honor, his attorney just walked in.
Judge, I'm sorry, that's my case. Defendant's here. Please have a discussion.
This is for arraignment due on Miss Nathan Sandage. Is that correct?
Yes, Your Honor. I'll be right back in.
I believe he's asking for a second call, Your Honor.
If that's okay, Your Honor, yes.
All right, put it on second call.
Thank you, Judge.
2026 CR 19854, State versus Rebecca K. Sipe.
Yes, Your Honor. We just need to put that on our November 10th date. We're waiting
November
on
the 10th. I believe that's still pending, and something she's filed is pending in the Court of Civil Appeals or Criminal Appeals.
I believe that's correct, Judge.
2026 CR 19896, State versus Michael Ross Schubert.
Your Honor, Mr. Eric Lockhart is the attorney on that.
For arraignment, do you wish a formal reading of the indictment?
Waive formal reading, enter a plea of not guilty, Your Honor.
Plea of not guilty is entered. General Sylvia, is this your case?
Yes, Your Honor.
You want to put it in November or some other date?
Let's go ahead and put it in November.
November 10th for status. All right, show Mr. Eric Lockhart is the attorney. He's been arraigned. Plea of not guilty is entered, set for status November 10th.
Yeah.
2026 CR 19883, State versus Jeremy L. Spencer.
Thank you.
Jeremy Spencer for arraignment. I'll put it on second call. 2026 CR 19861, State versus Henry Joe Stamps Jr.
Judge, I'm here for the defendant on that matter. And my client's attending via Zoom, so if the court wants to let him into the waiting room at their discretion, they can do that.
I don't have him in the waiting room.
He indicated to me before we started today's proceedings that he was, and was just waiting on you to let him in, Your Honor.
Your Honor, this is one of the two. This is the attorney that I gave the 7/15 due date to, and I have to re-email it with today's.
What are we doing in this case? Because we moved, today was supposed to be a trial date. So we had a Zoom link for yesterday and a Zoom link for today. since I moved the court from yesterday so that I could attend at the Court of Criminal Appeals in the Supreme Court, we are using yesterday's Zoom link. So your client was given the one for today, which is, anyway, it's understandable. But point I guess I'm asking, what do we need him here for this?
No, Your Honor.
Just let him know that he logged in on what should have been the correct day, but we're using a different day. So.
He's going to be disappointed, Judge. He wore his best suit today for you.
That's all right. Well, if that's the case, we can get him in here. If you want him to. All right. Then what are we doing, General Sewell?
Your Honor, we're going to be resetting this to the November date. There's lengthy discovery. Counsel and I had quick discussions, and I think there's some unredacted things they want to see. So if we could reset to the November date for status again, Your Honor.
All right. November the 10th.
Works for me, Judge.
Thank you, Mr. Townley.
Thank you, Your Honor. You have a good rest of your morning.
All right. Looks like then on page 9, 2025 CR 19769, State versus James R. Street. Mr. Street is for Raymond on a violation of probation. Anybody heard from Mr. Street to know where he might be? Right.
He doesn't have a bond. How is he not in jail?
Says hold for hearing, so we'll just show that just issue a capias for him if there's not already one out there. 2026 CR 19884, State versus Chevis Dwayne Titus. Mr. Titus, you are here today to be arraigned on a charge of aggravated robbery, theft of services, and vandalism. You have the right to an attorney. Do you plan to hire a lawyer?
I can't afford one.
Raise your right hand. Let's place you under oath. We're going to give you an affidavit to fill out that you're going to have to put all of your information in there, and you're signing it under oath. So make sure that it's accurate. I'll determine whether or not you qualify.
Yes, sir.
Miss Langley, Mr. Titus will be a General Sagi case, just so you know.
2026 CR 19892, State versus Skylar Joseph Edward Walden. Mr. Walden, you're here to be arraigned on the charge, an indictment charging you with aggravated domestic assault and domestic assault. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir. Yeah, I previously already bought one. And
you bought an attorney?
Yeah, the first go around. And then I was on a bond agreement, and my uncle tried to say I run him off the road, and yeah, it violated it. So now I'm here.
Your uncle tried to run your lawyer off the road?
No, he tried to say I run him off the road.
Your Honor, he had a case that was set out to be dismissed with no further problems. There were further problems. It was brought in, and he had a preliminary hearing. So the original charge has been bound over and is in front of you.
And that's what this charge is?
Yes, Your Honor.
So have you bought another lawyer?
I can, but I really don't want to. But if I have to, I will. I mean, I have proof I didn't run him off the road.
It doesn't matter to me whether you hire a lawyer or not, but what I want you to understand, whether you have a lawyer or not, the process is going to move forward the same. In other words, we are arraigning you today on this charge. I'm going to set you another status day, and you can either hire a lawyer between now and then, or you can represent yourself. I do not care. but it sounds like to me that the state intends to prosecute this case.
Yes,
So
sir.
you will either be representing yourself
All right.
and adhering to all of the rules of criminal procedure, rules of evidence, and get ready for a trial and represent yourself at a jury trial in front of 12 or 13 jurors, or you will have to hire a lawyer. I don't care which of those two you do, but I'm going to show that you're here today to be arraigned.
Yeah.
And I have been handed the indictment. I can read this indictment to you, or I can give you a copy of it for you to read yourself. Do you want me to read it to you?
Yes, sir.
Pardon?
Yes, sir. Yes, sir. You can read it. Do you need to read it?
Sure. In the Circuit Court of Cheatham County, Tennessee, at Ashland City, July term grand jury 2026. The grand jurors of Cheatham County, Tennessee, duly impaneled and sworn upon their oaths do present that on or about November 27, 2025, in Cheatham County, Tennessee, and prior to the finding of this presentment, Schuyler Joseph Edward Walden then and there did unlawfully and knowingly assault his uncle, William D. Walden, as defined in TCA 3913-101, by placing him in a choke hold, causing William B. Walden to lose consciousness as a result of strangulation, in violation of TCA 3913-102, a Class C felony, all of which is against the peace and dignity of the state of Tennessee. Count 2, the grand jurors of Cheatham County, Tennessee, duly impaneled and sworn upon their oaths do present that on or about November 27, 2025, in Cheatham County, Tennessee, and prior to the finding of this presentment, the said Schuyler Joseph Edward Walden then and there did intentionally or knowingly cause his uncle William Blake Walden, an adult or minor related by blood or adoption, bodily injury by grabbing him and putting him in a chokehold in violation of TCA 3913-111, a Class A misdemeanor, all of which is against the peace and dignity of the state of Tennessee. Show that you have been arraigned. The plea of not guilty will be entered. I will set you for status, and this will be for your attorney status as well as status to determine. You want that on November the 10th, General Sylvie?
Yes, Your Honor.
Your next court date will be November the 10th. You need to make a decision as to whether or not you want to have a lawyer represent you
I'll
or
hire
not.
another one.
And I will hand you a copy of that.
Thank you, man. Thank you. Yeah, I'll buy another one. Appreciate it.
All right. 2026 CR 19885, State versus Wesley Allen Weekly.
Judge, Mr. Flanagan represents Mr. Weekly. He's asked me to stand in for his arraignment.
All right. This is for arraignment, so we'll hand Mr. Weekly a copy of his indictment, which he can give to Mr. Flanagan.
We'll waive a formal reading and or plea of not guilty.
Plea of not guilty is entered. General Stevens.
He had just left, probably the
August
8/11.
Set for status August 11th.
Thank you much, Judge.
Thank you. 2026 CR 19902, State versus Angel Ann Williams. Ms. Williams, you are here to be arraigned on an indictment charging you with aggravated assault, child abuse, and neglect or endangerment of a child 8 years or less by placing the child in imminent danger, violation of the child restraint law, display or registration of your plates, failure to exercise due care by a driver, driving on roadways lane for traffic, financial responsibility law violation, possession of methamphetamine, reckless driving, violation of the seatbelt laws, and vehicular assault. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Are you able to hire an attorney of your own choosing?
Not at the moment. I just had a baby 2 weeks ago. I'm out of work on FMLA, short-term disability.
I'm going to give you an affidavit to sign and to fill out and determine whether or not you qualify currently to have an attorney appointed. Fill that out. You'll be signed. Raise your right hand. Let's place you under oath.
Yes, ma'am.
All right. Fill that out. We'll come back to you.
Yes, sir. Thank you.
Judge, Mr. Flanagan also asked me to do the same for Mr. Spencer. Is Spencer here?
Who was it?
Spencer was the last name. Jeremy Spencer. Don't know. Did he
Jeremy
file?
Spencer. All right.
Is there a
And you
what?
want him to stand in for him for arraignment?
Yes, I don't know if Mr. Flanagan, if there's a waiver in the
Jeremy
file.
Spencer in the courtroom. He was here earlier, but I think he may have stepped out.
Okay.
We'll show that Mr. Flanagan is his attorney, and we'll show he's been arraigned and the plea of not guilty is entered. Set it for. Do we know if this is General Stevens?
I'm sure.
It's driving while in possession of methamphetamine possession, unlawful drug paraphernalia, possession of firearm with intent to commit a crime.
General Sagan's case, put that on 8/11.
August 11th. Tw 2017 CR 18142 State versus Raleigh S. Conquest. He is at large. I think the remaining cases on the docket from here on out are all at large. Is that correct?
I'd like to address one if I may.
Yes, ma'am.
Your Honor, Mr. Edgar Harrison is on the at-large. He is actually present in the courtroom, and we have an agreement subject to Your Honor's approval.
All right.
This was a misdemeanor after a jury trial. He now works out of state. We can't transfer probation, but subject to your approval, he's about done. We would like to dismiss the violation and allow him to report via telephone. I've talked to the probation officer and the general, but they can't authorize him to check in by phone without your permission. Mr. Harrison?
All right. So if the probation department is in agreement with this, all right, then we're going to dismiss the probation violation, allow him to report by phone, and I will authorize that. So,
thank you, Your Honor. And would you like for me to submit an agreed order to?
I don't think that's necessary. I think the docket will just reflect what we've done.
Okay, thank you very
Probation
much.
if you need a signed order, I'll be glad to sign it. But all right. Thank you.
Thank you, Your Honor.
All right, I'm going to run through these remaining cases, which are all at large, in case we know anything about them. So, rather than after each one pronouncing that they remain at large, I'm just going to go through them, and if you know anything about them, let me know. What do you got?
Your Honor, we also have 19894 JD Binkley for plea.
All right, we'll do that one. You don't want to stand through 20 pages of that large.
Please, Your Honor, no.
All right, on page 1 of the docket, State versus JD Binkley, docket number 2026 CR 19894. Sorry. All right, I've been handed a document indicating that she is going to, or that Mr. Binkley is going to be entering a plea to driving under the influence of an intoxicant fourth offense. He will receive a sentence of 1 year in the Cheatham County Jail, suspended to probation after served 150 days. He may substitute drug treatment for up to 28 days of confinement. He must report to treatment or the Cheatham Jail within 15 days. He must report to the Cheatham County Jail within 24 hours of being released from treatment to serve the balance of his 150 days, a $3,000 fine, loss of his driver's license for 8 years, and he must report to probation in person. He will have no alcohol content, no alcohol as a condition of his probation. Interlock will be required for any future restricted license. Mr. Binkley, raise your right hand. Let's place you under oath. State your full name for the record.
J.D. Allen Binkley.
Step in front of that microphone, sir.
J.D. Allen Binkley.
Mr. Binkley, you're here today charged with driving under the influence of an intoxicant and some other charges on counts 2 and 3. But have you seen or been shown a copy of those charges? Talked them over with your lawyer, discussed with her the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to this charge or no contest. Rather, a no contest plea means you're not going to admit that you did anything wrong, but you're not going to contest the state's evidence. And I will hear from the state what their evidence would be, and I will use that evidence to find you guilty. Do you understand that?
Yes, sir.
If you want to stand right in front of that microphone, you don't have to lean
Sorry.
over it. You don't
Yes,
have
sir.
to lean over to it. Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
Do you understand that if you went to trial, you would have the right to have a lawyer, to have one appointed if you could not afford your own?
Yes, sir.
You understand that trial, you would be presumed to be innocent. You would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
Do you understand that at trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by use of a subpoena?
Yes, sir.
You understand that you would be presumed to be innocent. You would not have to testify at your trial, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading no contest, you're waiving or giving up your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Do you understand that's going to result in a conviction, and that conviction will be on your record in the future to make more severe the punishment you will receive if you are ever again convicted of a crime?
Yes, sir.
I am required by law to ensure that you understand the enhancement provisions of the law, and I've been handed a notice of DUI punishment that purports to bear your signature and that of your lawyers. Is that your signature?
Yes, sir.
Did you and Ms. Brady go over this document so that you fully understand the ever increasing punishment that occurs because of each conviction of driving under the influence?
Yes, sir.
And do you have any questions about that form?
No, sir.
Do you understand everything I've explained to you thus far?
Yes, sir.
Do you want to enter a plea of no contest and waive your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I can't accept your plea unless I'm satisfied that you are guilty and there are facts to support it?
Yes, sir.
Then I'm going to ask the state to come to the podium. If you wanted to turn that microphone on there, Mr. Stevens, you can do it at that table if you want to, whatever suits you best.
Your Honor, if this were to proceed to trial, the state would show that on or about January the 20th, 2026, Sergeant Aaron Scott with Ashland City Police Department was dispatched to the KFC in Ashland City, located at 495 Main Street in Cheatham County. Mr. Scott was notified, or Sergeant Scott was notified that multiple concerned citizens that they were concerned with the behavior of a Mr. J.D. Binkley, who drove his vehicle in a dangerous manner before entering the restaurant and then returning to his truck to drive again. The citizens stopped Mr. Binkley for police to arrive. One of the citizens told Mr. Binkley how this was better than him striking and killing someone, where Mr. Binkley then stumbled and nearly fell over. Mr. Binkley showed numerous signs of impairment, had open containers in the vehicle, and showed 6 clues on horizontal gaze nystagmus. Mr. Binkley then argued why he should have to do the other test. Mr. Binkley refused to provide a sample of blood for chemical testing, where a search warrant was granted. Analysis showed Mr. Binkley to have a BAC of 0.341. Mr. Binkley does have 3 prior convictions, which are noted in the charging instrument, making this a DUI 4th, Your Honor.
I'm not asking you to agree with those facts, Mr. Binkley, but you understand that's what the state's evidence would be if this case went to trial.
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Absolutely.
I feel like
Yes,
Ms.
sir.
Brady has done a good job of representing you competently.
Yes, sir.
Ms. Brady, do you know of any reason you should not enter this plea?
No, Your Honor.
Anything further from the state? Then J.D. Binkley in docket number 19894, I find you guilty, sentence you to 1 year in the Tennessee Department of Corrections. I'm sorry, 1 year in the Cheatham County Jail, suspended to probation after serving 150 days. He may substitute his drug treatment for up to 28 days of confinement. He must report to treatment of the Cheatham County Jail within 15 days. He must report to the Cheatham Jail within 24 hours of being released for treatment to serve the balance of the 150 days, a $3,000 fine. His license is suspended for 8 years, and he must report to probation in person. He's to have no alcohol in as a condition of his suspended sentence and probation, and the interlock will be required for any further restricted license. Now, he is to report within 15 days. I want a date certain for him to report. So let's pick a day.
30th.
July 30th. Mr. Binkley, you're being allowed to report July the 30th to serve your sentence. And what that means is that you're on probation right now. If you do anything to violate the law, if you drive a vehicle, even if you're stone cold sober, you get behind the wheel of a car and drive, if you drive away from this courthouse today, then you are violating this probation, and I will order that you be held for 1 year instead of 150 days. Do you understand that?
Yes, sir.
All right.
And just for the record, I've already told Ms. Brady it needs not report to the treatment or jail. That would be a felony escape. You'd be on felony.
And that would be an additional felony charge, not just the violation of this probation. So,
yes,
all right, that's the judgment of the court. He needs to see the probation department.
Your Honor, I have an order that if you'll sign it, that if you're ordering him to go to treatment, which is part of our judgment, that this will pay for his treatment since he doesn't have health insurance. And so I'd like to present that for your consideration.
this is why we're giving them the 15 days. They need this order prior to letting the bill in, so we don't think that before entering. That's why we did this.
All right, let's sign that order.
Thank you, Your Honor.
Thank you. Anybody else have anything before we start through these at-large cases?
Jody, follow that guy. Yeah, no.
You know, we had a second call for Nathan Sandage for arraignment. That's what he's
Your Honor, on behalf of Mr. Sandage, we would waive formal reading and plead not guilty to the indictment. I also have a notice of demand for speedy trial that I'd like to file now and serve to the DA at this time.
You're filing for a speedy trial?
Yes, Your Honor. I'd ask for a trial date on Your Honor's docket.
Your Honor, we do have these in even months. I was going to ask for the status in August 11th. And the second trial thereafter, that's fine with the state. We just need to get it on.
Well, he's demanding a speedy trial. How long will it take you to get your witnesses lined up?
We have 2 victims in this case. There's the officer and TBI, so we can set it, Your Honor. We can go ahead and set the trial.
Is it the case that it's set for August the 11th for status because it's in your docket and it would be normally on one of the other judges?
Yes, sir.
So I'm going to set it for August the 11th and set the motion for speedy trial to be heard by that judge on that day. All right, August the 11th.
Thank you, Judge. Thank you.
Show that Mr. Sandage has been arraigned. The plea of not guilty is entered. And the motion for speedy trial is set for August the 11th to be set on that day.
Thank you, Your Honor.
Yeah, just mark that file as well. Okay, let's bring out the inmates. Mr. Vaughn, we're going to do Kenneth Bearden first. Okay.
Yes, sir. We're ready for it.
Oh, that's a motion for speedy trial. Oh, no, that one guy.
Thank you, sir.
Thank you, ma'am. Come on, Beard. Judge, it's going to be for plea today. Mr. Bearden actually has two cases going on. He's going to be pleading in 19816. 19804 is going to be dismissed in settlement. He also has a VOP. So we've got three things kind of going on here today. As to 19816, he's going to plead to count one aggravated assault, C felony. He received 5 years in TDSC, suspended to supervised probation after he does 10 months, credit for time served. And he must complete the inpatient treatment program at One Life, or probation will be violated. He needs to pay costs, forfeit the weapon, no contact with victim. And this case will run concurrent with 19005, which the VOP stems from, and the VOP will be dismissed. But it is important to state on the record again that his probation will be violated. This is a 100% serve aggravated assault. So if he doesn't complete that, he will have to pull the whole 5.
Right.
He's got credit from 10/30 to today's date, making his out date potentially 8/30.
Mr. Bearden, raise your right hand. Let's place you under oath.
Yes.
Thank you. Step in front of that microphone. State your full name for the record.
Kenneth Mitchell Bearden.
Mr. Bearden, you're here today charged with a number of different counts. You've heard what the agreement is. Have you been able to go over this with your lawyer, discuss with Mr. Vaughn the range of punishment you're facing and any possible defenses you might have for all of these charges?
I have, Your Honor.
Well, it's indicated that you want to enter a plea of no contest. That means that you're not going to admit you did anything, but you're not going to contest the state's evidence when they tell me what their evidence would be if this case went to trial.
Yeah, yes,
You
sir.
understand I will use that evidence to find you guilty according to this agreement.
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender.
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand you would be presumed to be innocent at trial? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Do you understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial and to an appeal by entering this plea of no contest?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied you are guilty and there are facts to support it?
Yes, sir.
Then listen as the state tells me what their evidence would be if this case went to trial. General?
It's not. No, it's not. Oh, yeah, it is. Okay. On November 2nd, 2025, officers responded to 1106 Cedar Hill Road in reference to a domestic assault between roommates. When they responded, they spoke to a Mr. Hedgepath who explained that he had been in an argument with the defendant, and during that argument, the defendant had displayed a handgun. That would be the basis for the aggravated assault plea, Your Honor.
All right, I'm not asking that you agree with those facts, but do you understand that's what this, what the state's evidence would be if you went to trial?
Yes, sir.
You still wish to plead non-contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Vaughn's done a good job of representing you competently?
I do.
Mr. Vaughn, you know of any reason you should not enter this plea?
No, Judge, I don't. I do want to make, I made an error on the jail credits. I believe I put it to today's date, 2025. If you wouldn't mind putting that as a 6, I would appreciate that.
That should be July 15th of 2026. All right, I've made that change. Anything further from the state then?
No, Your Honor.
Then Kenneth Bearden in docket number 19816, upon your plea to count one of no contest, I find you guilty, sentence you to 5 years in Tennessee Department of Corrections. That will be suspended to supervised probation after you serve a total of 10 months with credit for time served. You must complete an inpatient treatment center program at One Life or your probation will be violated. You must also pay the court costs and forfeit the weapon that was involved in this case. You're to have no contact with the victim in this case. This case will run concurrently with docket number 19005. In that case, the violation of probation warrant is dismissed as a part of this agreement, and case number 19804 is dismissed as well, along with all other counts of this docket number 19816. That's the judgment of the court. He'll need to make sure he sees the probation department once he's released. So,
Thank you, Judge.
thank you. We have one more inmate, I think. Who is this inmate?
Mr. Vaughn said it's Mr. Street. That's you, sir. I guess we found him. He wasn't.
So this is a probation violation.
Yes, sir. I think it's just a random for him on that.
All right, so James R. Street, come to the podium, please. Mr. Street, you are here today to be arraigned on a probation violation. I want to make sure that you understand you have the right to an attorney if you wish to have a lawyer to represent you.
Yes, sir.
Mr. Vaughn with the Public Defender's Office will be appointed.
Winner plea not guilty on this, Judge.
Plea of not guilty is entered.
We can handle this on the 28th.
July 28th. You have those cases where they've been given affidavits. All right, anybody else in the courtroom that today understood you had a case, but your case has not been called at least once? I'm gonna go back through these cases where the request was made for an attorney, Angel Williams. Williams, I believe you were placed under oath and asked to swear the information, but right now you work at A.O. Smith and you make $974 a week.
Yes, sir.
Under those facts, you would not be indigent, and therefore you would not be entitled to have an attorney appointed for you.
Okay, yes, sir.
But I will give you an opportunity to hire a lawyer, and if you hire a lawyer, we'll reset your case to give you plenty of time to do that. Is Ms. Williams one we can set in November?
No, Your Honor, that's going to be a General Stevens case.
All right. Then I need to set it for, let's set it for the August 11th date. We'll see what can happen at that point. But
The clerk has some information.
Judge, well, this is the case that we talked about last week. She has to turn herself in by the 17th. I don't know if that makes sense. It's all coordinated, and she will be incarcerated until 17th.
after the 17th of July, November.
This is the young lady that had the 5-day-old baby that we spoke about. She has a
Right.
high bond, and so you give her time to hire an attorney or 5 minutes to make that bond.
But I I didn't think it was November 17th.
It's not. It's 17th in 2 days.
It was supposed to have been yesterday, I think. So 15th. It was supposed to. She has until Friday to surrender herself to make bond. So, Miss Williams, unless you're able to make bond, what is the amount of her bond?
75,000.
You expect you're going to be able to make that bond?
No, sir. I was trying to see if it was possible if I can honor my OR for my child and my job, and I can afford an attorney if I'm able to stay out on my OR because I go back to work in August, and I'll be able to afford one if it's pushed back far enough.
Well, there was no OR. I don't think there was an OR bond. I think what happened was because when the officer arrived to serve you with this warrant, he found that you were holding a 5-day-old infant.
Yes, sir. My son is downstairs. I have a 2-week-old.
And for that reason, rather than take you into possession or take you into custody, they requested that I consider giving you an opportunity to surrender yourself at a later date. So I gave you until the 17th of July to make arrangements on for your child before you could go into custody. I'm going to put this on July 28th for us to determine whether or not you should be granted any disposition on the bond. You need to understand that you're charged with a number of very serious offenses.
Yes, sir.
And you're not indigent at the present time, but that's because you're being allowed to remain on bond or being allowed to turn yourself in on this charge. And I'm going to set it for the 28th, but you have until the 17th to surrender yourself and make arrangements for your bond.
Okay, yes.
Okay. So I'm going to show that you want me to read this indictment to you later this afternoon, or do you want to read it yourself?
You can read it, sir.
Pardon?
You can read it.
All right. Have a seat.
I'll
We'll come
waive
back
it.
to you after lunch.
She said she wants to waive it, Judge.
Oh, all right. That's fine. We'll do that. I'm going to show that she is going to be for attorney status on July 28th so that I can determine what her situation is about her bond at that point in time. So we'll show that she's waived the formal reading of the indictment, enter a plea of not guilty, and then we will come back to her on the 28th. You have to report to jail to turn yourself in on this warrant on Friday the 17th by 6 p.m.
Yes, sir.
Okay. Hopefully you can make arrangements on your bond until then.
Yes, sir.
All right. Anybody else that we have to deal with?
Just me, Judge. I guess we're going to have very small jurors. Judge, I think the only thing I got left is Mr. Spencer for arraignment, and I have a waiver, but it's at 95 White Ridge Road. I will email it back over here.
I think we'd already
you already taken care of
arraigned them
Spencer?
and taken care of because you have Mr. Vaughn standing in for
Okay.
it. He's a very competent attorney, so
He is a very competent attorney, but I got to come over here and see the new courtroom. So it was worth the trip to see all y'all. And fine. I never know when I'm gonna need an alibi, and so I was here, and these are credible people. So
that's true. So where are you going from here?
I've got a cataract thing I got to do this afternoon. So
Okay.
go do that.
We'll also have prayer for Mr. Flanagan because at his age, things like that start falling apart. So
I'm shocked that I lived to this age. I'm glad I did.
I know you're the living embodiment of what one of the Rolling Stones said. If I'd known I was going to live this long, I'd have taken better care of myself. So.
Yeah.
All right. This will be State versus Shivas, Dwayne Titus. Mr. Titus, you have filed an affidavit. Is all of that information true and correct?
Yes, sir.
I don't know if we swore you in, but Raise your right hand. Let's place you under oath to make sure.
Yes.
You are working part-time, is that correct?
Yes, sir.
And so at this point in time, what is your average weekly wage?
About $380.
So you're in times 4, that's about $1,200, $1,600 a month, something on that order.
Yes, sir.
And you have 3 children.
Yes, sir. 3-year-old and a set of twins out of 2.
I find him to be partially indigent and I order that he pay an administrative fee of $250.
Wait for more reading or plead not guilty, Judge.
Plead not guilty is entered. Status date for Mr. Titus.
Should be 8/11. That'll be general savings. 8/11, Your Honor.
8/11. Okay.
See this later. Make sure you put it on.
Status date would be August the 11th.
Talk to Tim. Who's Tim? Your attorney. Go over.
Sapphire Linton. So is your income from Social Security
Yes, sir.
Administration, that's the sole income that you have?
Yes, sir.
And is all of this information true and correct? So help you God.
Yes, sir.
All right, I found her to be indigent. We'll appoint the public defender to represent her.
Judge, we're going to have a conflict on this one.
Okay. Who won? All right, we'll appoint Sunny Stevens to represent her since she's already familiar with the case.
No.
Standing in for Ms. Stevens.
No. Can I get a different one?
Pardon?
Can I get a different one possibly?
No, ma'am, you don't get to choose.
Okay, thank you, sir.
You can hire one if you like.
Yes, sir.
All right.
What's the date on that?
Should be 8/11. No, it's our date. So November 10th.
What day?
November 10th. I think.
November 10th. All right.
Yes, sorry, Your Honor. Yes.
Thanks.
Give that to Miss Steve.
Okay, thank you.
Jonathan Kane Krantz. Mr. Krantz, you filed an affidavit, but you don't really give us any income amount. I mean, I know you work for yourself as self-employed, but on an average month, can you give me some idea of what you make?
Your Honor, it honestly varies. It could be 500, it could be 5,000. It strongly varies.
Did you file taxes last year?
Yes, sir. 31,000. I believe is what I filed for.
All right, I find him to be partially indigent. I will report the public defender, but in order that he be required to pay an administrative fee.
We'll waive a reading and a plea of not guilty.
Plea of not guilty is entered. Status date
11/10.
November 10th.
How much is the fee?
Pardon?
How much is the fee?
$250.
Do I pay that to the court clerk?
Yeah, but you can make arrangements with them to pay it. So you don't have to pay it today. Anyone else who has a matter that I've not addressed?
This isn't on the docket, but there's a Donovan Hilliard. Docket number is 19707. I did a superseding indictment on him this past grand jury. I'm assuming he's been served with it, but could we add him to the 28th?
Sure.
And the reason I wanted it on the 28th is because he's set for trial in September with Judge Lockhart Mash, and I wanted to get that procedurally out of the way so I can start working toward the
All
trial.
right, put him on July 28th. Okay. Everything else is at large. So I'm going to just run through them in case and call the cases so that if anyone knows anything about the status of these individuals, I will pause long enough for you to tell me. (2017) 18142 Raleigh S. Conquest. 2022 19256 State versus Larry Corbin. 2022 19276 State versus Dylan James Decker. 2025 19777. I'm sorry, that's also James Decker. 2015 17594 DeCarlos D. Fentress. 2023 19509 State versus Eric Lee Ferrer. 2022 19285 State versus Jessica Gomez.
Thank you, ma'am.
2024 19549 State versus Jorge Gonzalez Barragan. 2021 19114 State versus Damon Greenlee. Do you have anything, Mr. Vaughn?
Just really quickly, Judge, Mr. Titus that we just got appointed to, while we were in court, he received an offer with MTA for a job. 8/11 is his second day of work. Is there any way for his status date it's going to get moved to what? February?
December.
Yep. It's going to get moved to December anyway. Can we just go ahead and do that so he doesn't have to miss the second day?
Move it to December what? December 4th.
Thank you, Judge.
Next time, if you need something, just wave at me if I'm going through.
I didn't want to interrupt you, Judge.
I'm used to being interrupted. 2024 19564 State versus Gary W. Henson. 2024 19550 State versus Susan Binkley High. 2026 CR 19900 State versus Matthew J. Hunt. 2021 CR 19217 State versus Robert Samuel Jeffrey. 2021 CR 19217 State versus Mary Johnson. 2024 CR 19593 State versus Austin M. Lindsay. 2021 CR 19069 State versus Johnny W. McDonald. 2024 CR 19594 State versus Christopher Dale Meese. 2023 CR 19385 State versus Tatum Bradford Moss. 2022 CR 19314 State versus Robert A. Perry. 2022 CR 19268 State versus Brian Riebenstorff. 2013 CR 16885 State versus John Shippers. 2023 CR 19460 Nicholas Antonio Shelton. 2019 CR 18919 State versus Trevante D. Smelly. 2023 CR 19462 State versus Joshua Ward Stewart. Wonder what it was like to go through elementary school and your last name is Smelly. 2023 CR 1939389 State versus Deshaun Stone. 2021 CR 19178 State versus Sherry N. Weston. 2021 CR 19179 State versus Sherry Weston. And 2017 CR 18299 State versus Aubrey N. Whitworth. 2012 CR 16727 State versus Dustin Wigginton. State for 2020 CR 19010 State versus Mickey E. Womack. All right, I've gone through all of the at-large cases. Is there anything that anyone has that we need to address on the record? If not, then we will stand adjourned. Right now, we looks like I have motions in Dickson County tomorrow, motions in Dickson County on Monday and Tuesday. And then I'm back here for Chancery on the 22nd and the 27th. Then we have VOP here on the 28th. Then I'm back in Dickson for the Chancery on the 29th. Then I'm in Humphreys County in Dickson for the 30th. And then I have criminal motions in Dickson County for the 31st. All righty. That concludes our business for today, so we will stand adjourned.